I remember sitting in my office with just the computer screen light on, and I had these big glass windows that looked out over the Brisbane River. There are no houses on the other side, it's just forest. And I was looking out into the darkness, and I just felt that that's just like where my life was, right there. Nowhere to go.
Scott Balson has made quite a name for himself as the author of the often controversial One Nation website.
An internet author could be prosecuted for contempt of court for publishing the name of a state MP who's on child sex charges.
The Attorney-General has launched an urgent investigation.
A man associated with the One Nation Party appeared in court today.
The website linked with One Nation Party.
The website has links to One Nation's homepage, which Mr Balson also edits. Mr Balson arrived with One Nation supporters.
My political views are the catalyst behind certain events that have taken place before today.
Mr Balson is pleading not guilty.
We have a Queensland MP who's facing 50 child sex charges, making laws that affect me, you and everybody in the state. If that's justice in Queensland, God help us, because the law isn't.
Melanie Went, National 9 News.
In July 1999, Scott Balson was charged with naming Labor MP Bill Darcy as a man facing child sex charges on the internet. At the time, Darcy faced 50 child sex charges, including rape, and was sitting in Parliament as the Deputy Speaker, supporting Peter Beattie's minority Labor state government.
Back in January 1999, I published a book called Murder by Media, which looked at the really the very biased way that the Australian mainstream media reported on political events. And that book didn't go well with the Courier Mail because it referred to the Courier Mail to a large degree and the way they were misreporting. As a result of the book, I started getting some very negative reports in the Courier Mail in which I was called a racist. I was referred to as anti-Semitic, very derogatory comments about my web page, which I was carrying on with the One Nation Party. Following that, I had reports that the Courier Mail were out to get me. 6 months after my book came out, I published the name of a sitting Labor Party politician by the name of Bill Darcy, and by publishing his name on my online newspaper, I put myself in a position where I could technically be charged with a crime under the Sexual Offences Act. And what happened was the Courier Mail, immediately they saw this comment about Darcy, lodged a complaint with the DPP, and as a result I was arrested.
I was not surprised at all that Scott was charged with this offence because he was only doing what he felt was right in exposing the truth about what was going on in the Queensland government.
As a former police sergeant, 30 years of the Queensland Police, worked at the coalface, it was a charge that an astute policeman wouldn't take on. You wouldn't get anywhere with it. There again, that's politics. It was pushed.
What I used to do each day was I used to put the headlines of the Courier Mail articles onto the internet with a summary of what the article was about, and then actually just had that as a daily archive of news online. It was very interesting because of the global nature of the internet. I suddenly started getting calls from expat Australians who started following my news of the day. The comments and the discussion that came out of that became part of an addendum to the main part of my paper as it evolved, and really became almost like an open forum where a whole range of issues were discussed, which started moving towards the area of globalization, which became a real big concern with me when I saw what was going on behind the scenes and wondered why the mainstream media weren't really tackling issues which affected the average Australian.
It all comes down to the Australian way of life and a fair go for a bloke. And it is about doing the right thing for the Australian people. Bugger politics, it's getting the job done.
You can't see Scott in isolation, you've got to see it in the broad picture. Queensland, in its post-Fitzgerald era, is not the state in well-being. As a matter of fact, it's in a worse condition now than what it was pre-Fitzgerald, and it's very sad.
In Queensland, unfortunately, in the major capital, Brisbane, we only have one newspaper, the Courier Mail, so it has a total monopoly on people's minds, and it used it very effectively. My first experience with the One Nation Party was at the launch, where I had a fairly extensive report with lots of photos that I'd taken and all the positive stuff that I'd seen at the launch. And after posting it up on the internet, got my copy of the Courier Mail and was blown away by the difference in what they reported and what had happened.
The local media here in Queensland has greatly let down the Queensland public in terms of informing them of what's going on inside the government.
The treatment of the One Nation Party by the mainstream media was absolutely abysmal, and in fact that's too kind a word. If we're talking about balance and ethics in reporting, there was none. All they were looking for was a negative slant, and they latched onto that, and that became the story. There was never anything positive said about the party.
In relation to what happened to Scott, as I understand the situation, the paper played a role in wanting him to be charged, which is ironic in the sense that it appears that the paper also identified Mr. Darcy in terms of the person where he worked, which under the Act you weren't supposed to do.
The Australian national news of the day started to focus on challenging the mainstream media on how and what they reported on the One Nation Party.
I know for a fact that my online newspaper, following the launch of One Nation, was having an enormous impact on the Courier Mail. I heard this firsthand from a reporter. What was happening is that readers over the Atherton Highland, which was mainly One Nation territory and very, very strongly One Nation territory, they got the Courier Mail traditionally, but when they got my online newspaper and realized the Courier Mail were presenting a totally distorted point of view, they started boycotting the paper. And instead they started actually printing out and copying my simple little news of the day and handing that around, which had an enormous impact on the sales of the Courier Mail in that area. At that time I was informed, and this is not long after Murder by Media came out, I was informed by the same reporter at the Courier Mail that they were out to get me, to close me down. I was aware that the Courier Mail had a Balson file, which again is quite extraordinary. It's like communist Russia. Here you had a mainstream media paper owned by Mudoch, which had a file where they kept copies of all my back issues of the news of the day. And I found out about that because after I published Murder by Media, they started dipping through all that information and compiling very negative articles based on not only what I might have written, but what people had said in the forums, which were open discussions on a whole range of issues. Just like with One Nation looking for the worst, and then making that as if that was the par for the course as far as the paper was concerned.
The media plays a vital role in any democracy, but it has to be prepared to pursue the truth for as long as it takes to get the truth out. I mean, the trouble nowadays with communications is it's all 10 and 15-second grabs. If you can't get your story over and done with, then you're dead.
Because of my online newspaper with daily reports comparing what had happened and what the media had said, I had an enormous amount of information about the discrepancy in the truth when it came to the reporting. And a lot of people who were followers of my online newspaper said that they knew of people who had no access to the internet, so they had no way of seeing how dishonest the media reporting was. So what I did was I actually went back through the old newspapers that I'd put online, took extracts and put the book together with that. So it was basically a summary of what had been carried from the online newspaper. Murder by Media had a very big impact right around Australia. I found it interesting the mainstream media totally ignored the book. In fact, there has never been a reference to Murder by Media anywhere in the newspapers. The only place that we got coverage was actually in the radios through people like Howard Sattler, who did give me airplay. And as soon as they did, we had an enormous demand for the book because people realized that there was something wrong. The book itself was carried for about 2 weeks at Dymocks, who are a preferential supplier. Within those 2 weeks, we sold hundreds of books through Dymocks right around the country, and all of a sudden the book was pulled. It was actually withdrawn from the shelves of Dymocks at the direct orders of Kerry Packer. The launch of Murder by Media was definitely the start of the problems that I faced later, yeah, most definitely.
In late August 1998, the Courier Mail carried a headline story revealing that Labor MP Bill Darcy was facing a large number of child sex charges.
Labor MP Bill Darcy has refused Premier Peter Beattie's advice that he resign over child sex allegations that threaten the stability of Queensland's minority government. Mr Beattie, who did not publicly identify Mr Darcy, told him during a 45-minute meeting yesterday that he should quit Parliament in the interests of himself, his family and the government.
Following that article, the television news stations carried reports in which Peter Beattie let Darcy's name slip during a press conference. And Australia's only national newspaper, The Australian, named Darcy in all states except Queensland.
Mr Bill Darcy, he's a nasty bit of work. I mean, everybody knows that. He's a pedophile. He's behind bars for many, many years. At the time that I published his name, in Queensland we had a hung parliament, which meant there was equal number of people for and against the government. Bill Darcy was the deputy speaker, and the Beattie government put him into the speaker's chair, which meant he had the casting vote at the very time they were talking about pedophilia. I mean, how sick is that?
They well knew that Bill Darcy, in those days, they all knew, for years they knew that Bill Darcy was being covered up there as a child sex offender. They did nothing about it. They're doing the same thing today. They're covering up issues that should be talked about in the public.
Looking back, it makes me quite ill that he was still sitting in Parliament in the Speaker's chair at that particular time. He knew whether he was guilty or not, and according to the courts now, he was guilty at that time, so he should have had the intestinal fortitude to step aside. It makes me sick now. At the time, I still gave him the benefit of the doubt, but he knew he was guilty. He should have stepped down, simple as that.
And I said, I've had enough. The Courier Mail have already published his name, the Premier's already published his name, and I put his name up on the internet.
Woodridge MP Darcy's involvement in the Netbet affair would appear to be as the money man. The MP is a millionaire facing child sex charges and would have the financial clout to back.
I was alerted to the fact that the radio had been talking about this article which carried information that shouldn't be published by my son. He phoned me up in the morning and said that they'd just been talking about my newspaper on the radio and saying that I had the name of someone up there that was in breach of an act. I was quite shocked because I hadn't realized that the media would be taking the sort of lengths or going to the sort of lengths that they were just to get to me.
It wasn't necessarily so much that I was surprised that he was charged, such as I know anything about the Sexual Offences Act. It was more a matter that if it was good enough to charge him, then it ought to be good enough to charge others who had done what he had done, but on a wider scale.
After finding out that the media was saying that this article was illegal, I immediately took it off the internet and I put up the next day's News of the Day. I then phoned up the person in the DPP who was handling the case against Darcy and said that I had actually published the article, I had nothing to hide, and he asked me to come into town and see him at the courthouse. The media apparently knew more about what was going on than anybody else. What happened was at the very time that I was phoning David Bullock, a reporter at the Courier Mail was handing out copies of my article that had been published the previous day to reporters at the steps of the Magistrates' Court.
The Courier Mail would later try to claim that they were not the complainants against Scott, a claim that would later be destroyed in court by a witness under oath.
I went to the Queensland State Library because I knew they carried an archive of all the old Courier Mail newspapers, and I had one intention in mind, and that was to demonstrate that the government was in breach of the act that I was being charged under. And to do that, I went to the archive section of the Courier Mail, and as a member of the public I went through the old newspapers, found the articles that had been published in 1998 in which Darcy had been named by the Courier Mail, printed out those articles, and then I got a fellow from the State Library to actually witness that on that day I'd got copies of those articles, and I left. The argument used by the Courier Mail that they'd published the name before he had been charged fell away, because I had a letterhead, the Courier Mail letterhead, with the articles published after he was charged but before he was committed for trial. And of course the government, by being the body that actually provided the articles to me, were in breach of the Act as well. In effect, what should have happened, if the government was fair dinkum, was they should have pulled those archives from their records, which they didn't do. And the same thing applied with papers like The Australian, because The Australian outside Queensland published his name in their papers, and of course people travelling in planes flew into Queensland with those newspapers naming him, and they were immediately in breach of the Act. So the whole thing was a total farcical event. The article by David Solomon on the day of my arrest, which is the 30th of July 1999, was quite typical of probably my greatest concern about reporting.
Lack of legal knowledge is a problem in political ploy over sex charges. A person who says another is about to be charged with a criminal offence risks being sued for defamation if they are wrong, and perhaps even if they're right.
David Solomon quite clearly has very strong contacts with the Labor politicians. If you look at his history, you'll see that he's been on some very senior committees for the BT government. He clearly can pick up the phone and speak to the Premier directly. It's this sort of contact that really worries me, because you don't have to put something in writing. Just a nod and a wink and you can go after someone, which is a real concern. And if you look at my case, there were some very strange things that happened quite clearly between the media and the politicians. The Courier Mail quite clearly had taken sides. I have absolutely no doubt about that.
On the day Solomon's article appeared, Scott received a phone call from his lawyer informing him that the police were going to arrest him over the charge.
Probably the greatest pointer to the level of interference of politicians or government into my being arrested was the speed. There was quite clearly absolutely no evidence that linked me with the article at the time I was arrested. Even at my trial 9 months later, they couldn't produce any evidence that I'd written the article. That's how crazy it was. Now, you don't go after murderers until you have concrete evidence. And here they were on an offence which was no worse than a summary charge, which is the same as a speeding fine, trying to concoct evidence against me. The only evidence they claimed they had was this phone call from someone claiming to be myself, speaking to David Bullock, and on that basis they arrested me, even though Bullock at the trial admitted he didn't know who I was.
Without doubt, being here brings back very strong memories of the most traumatic day of my life. It was the day that I was arrested. You've got to realize that a little bit earlier than when I came here, I had read the article by David Solomon in the Courier Mail, which called for me to be arrested. And a couple of hours later, I'd had a phone call from my lawyers telling me to phone up Leanne Myers, the arresting officer, to set a time to come to the Brisbane police station to be formally charged. I set up a time for 10 o'clock in the morning. And as I approached the entrance to the police station here, what I noticed was that standing against this pillar was a reporter and a photographer from the Courier Mail, and they were waiting for me. When they saw me coming up the path, they tried to intercept me, and I just ran up the stairs and was able to get away from them. But the issue here is that I had a private phone conversation with the arresting officer to set up a time for 10 o'clock to meet her, to be interviewed, and we had two reporters waiting for me to arrive at that time.
It was almost like the police delivered me right into the hands of the media.
Inside the police station, Scott met with Leanne Myers. He was presented with a bench charge sheet stating unlawful documentation as the basis for arrest.
Just imagine you got a speeding fine, and as a result of that speeding fine, you're told you have to go to the Brisbane police station to face an arrest. You go to the Brisbane police station. You're taken to the watch house. You're put into a police cell, and I've got to tell you that cell was disgusting. It was covered in slime and saliva, and obviously they'd had people in there who'd been spitting. The cell itself was the size of a bed with bars going up to the ceiling. While I was in there were senior police coming from behind the scenes and looking at me and laughing. They obviously knew who I was. It was like I was an animal in the zoo. I was kept in there for about an hour while they were processing papers, as they called it. After they'd done that, they then took me off to be fingerprinted. And again, imagine we're talking about a summary charge here. In other words, the same as the speeding fine. I was fingerprinted. I was photographed with a number, a criminal number, face on and side on. I was in there for several hours. And before I was allowed to leave, I was put on bail, which I was on for 9 months. And as we were leaving, the arresting officer said, I'm out to get a search warrant now to go through your house and your home and your office. Will you please wait for me so we can follow you home and do this? Which I obviously complied with. So it was a pretty horrific and extraordinary experience.
After following Scott back to his home, the 3 officers spent almost 3 hours executing the search warrant, copying the entire contents of his hard drive to a briefcase computer. Included in the files downloaded were over 2 years of confidential correspondence between various One Nation officials and Scott. On the 13th of August 1999, within minutes of pleading not guilty, the earliest possible trial date was set, the 6th of October. Scott was then quickly down the lift and walking into a media frenzy outside.
And I basically said that I felt I was being singled out.
Particularly nowadays, when you live in a society that has 9/11 and where people are attempting to blow planes out of the skies, people look to government to protect them. And so when you have government breaking the law and engaging in cover-ups, it becomes frightening for the ordinary people. And I believe that the only way you can instill confidence in people in terms of government is when equality before the law operates. And that's the significance of what happened with Scott. If it was good enough to charge him over his publication, why not others who did far worse?
Joan Gordon is a wonderful old stalwart of the One Nation Party. She lives north of the river, and she had some very good contacts in the One Nation Party, and she was able to help set up a number of protesters at my first appearance in court. And of course they had banners up which said Scott Balson, political arrestee and political prisoner and stuff like that. And it was quite a carnival occasion on that first hearing that we went through.
They'll do it to anyone who wants to expose the truth. They don't like being proved wrong. And the government was wrong in doing what they did.
When I first appeared in court, because there were three trials, in my first trial, I wasn't sure what was going to happen. I've never appeared in court in my life before. My QC warned me that because the Attorney General was personally involved in the case, there was a very high possibility that I would be found guilty. And that weighed down very heavily on me. When we got to the courthouse, all the media were there, which again was very stressful. The protesters were there looking very colourful, and I knew a lot of them. I went and had a chat to them, and then I walked up the stairs and into the courthouse to face the music, as it were. As I came up the street, the media saw me and they came rushing down to meet me as I walked up to the magistrate's court, and I just ignored them and went across to each protester and shook their hand and said thank you. When I went through the doors and sat down before the bench, when my case was called up, again the media were just lining the walls. There were dozens of them. And the whole thing was a total farce. The police prosecutor got up and he said that his case wasn't ready. He said he hadn't got all the evidence in yet. This is now months after my very speedy arrest. My QC then got up and claimed costs, but because the trial was being adjourned, the magistrate said, look, that'll be decided at the next hearing. I didn't know what was going on. I just sat there and all this legal jargon was going backwards and forwards and backwards and forwards. And it was very distressing because I knew that by having an adjourned trial, it was costing me $5,000 a time in legal representation. So basically $5,000 had gone down the tubes because of the police incompetence.
The case was adjourned until the 10th of December, with Scott remaining on bail.
I made a statement to the media at the end of my first adjourned trial. Basically, I said that it was quite clear to me that the arrest was politically motivated, and the media did actually publish that night on most of the television stations.
One Nation's internet author Scott Balson has had his court case adjourned on charges of breaching the Sexual Offences Act. Mr Balson arrived with One Nation supporters.
My political views are the catalysts behind certain events that have taken place before today.
The media never took an angle. At a private level, a couple of the people who were actually at that first trial told me that the reporter from Channel 10 actually said to them that this is a complete farce. She said that it's clear that you know, there's something going on behind the scenes, and she didn't know why this was all happening because everybody else was naming Darcy. But apart from that private comment, it was a very factual type of reporting. You know, Mr. Balson said this is what happened in court today, no angles given at all. Not long after that first trial, I met with my legal team, and I was under a tremendous amount of stress. The Courier Mail had been running a series of very negative articles about me, naming me in particular where it came in relation to the web. Every one basically said that I'm some kind of a scum. It was very traumatic. My business had just ground to a halt. I was too scared to even go and talk to people. I nearly went bankrupt as a result of what was going on behind the scenes. And my QC said to me, he said, look, he said, I don't know who you are or what you've done, but you've upset someone who's very important, because they wouldn't normally be doing this against an individual. He obviously knew I was involved with the One Nation Party, but I certainly wasn't Pauline Hanson, so there must have been another reason why they were doing this. The only reason I could see as far as the government was concerned why they'd be doing this is because of my very comprehensive page on their cover-up of the shredding of the Heine documents, which had been used by the Queensland One Nation MPs in Parliament as a source of reference to embarrass the BT government.
The alleged criminality in the matter is quite demonstrable, that government destroyed documents when they knew they were required for court, and when they also knew they contained evidence about the abuse of children, potentially involving the pack rape of an Aboriginal girl, which fell into the category of criminal paedophilia. But the law enforcement authorities in Queensland cannot face the prospect that they may have to charge the entire cabinet. And so what they are suggesting is that it's not in the public interest to charge the cabinet, whereas it's in the public interest to charge a Baptist minister who did exactly the same conduct, or to pursue a person like Scott, whose breaking of the law pales into utter insignificance against the criminality involved in the Heine affair.
I resigned from the One Nation Party, not directly as a result of my court case, but more because of what was happening to the One Nation MPs at that time. The executive, we're talking about the two Davids and Pauline Hanson, had walked away from their responsibility regarding the absolute chaos in Queensland following the deregistration of the party. And there was no leadership as to what direction to take, how to fix the problem. Everybody was running around like headless chooks. I knew the MPs personally. I knew that they had real concerns about what was happening with the funds within the party. They were at a point where they were going to move away from One Nation. And at that point in time, I said to Pauline Hanson, you've got to get away from these two guys. You've got to break away. And she said she refused to do that. And I said, right, I'm resigning from the party.
Following his resignation, and just 2 days before the hearing, Scott's lawyer informed him that the Crown Law had just faxed documents sought under the subpoena.
And he said, Scott, I've got a document here that I think you'll find very interesting. It clearly demonstrates that our suspicions are correct. And under freedom of information, he had received from the DPP a copy of the complaint made by the Courier Mail. So it clearly demonstrated where the complaint had stemmed from. And there was absolutely no argument about it. Despite the fact we had the document, the Courier Mail months later still wrote articles saying they had nothing to do with the complaint, which is quite extraordinary.
On the 9th of December, Scott sent a notice to the press alerting them to some startling revelations that he would be making about a major media outlet after the court case. However, within hours of the notice being sent to the press, Scott's lawyer informed him that the police would be asking for the charge to be dismissed and then reissued in the Ipswich Magistrates Court.
Well, at the second trial, what happened was quite extraordinary again, because another $5,000 a day in legal costs for me. We arrive in the court and are told by the police prosecutor that they are now going to have the case withdrawn because it's been brought up in the wrong jurisdiction. They'd been bringing it up in Brisbane, where it should have been in Ipswich. And before anything happened, he said this. He said, look, we're withdrawing the charge because it's in the wrong jurisdiction. My QC then got up and there was this long debate again about costs. At this time, my costs were about $10,000, my legal costs. And the magistrate, who I really did not warm to at all, despite knowing what my legal costs were, only ordered $500 be paid by the police towards my legal costs. As I walked out of the court that day, I was served directly with another summons to appear in the Ipswich Magistrates Court. So they wasted no time at all.
I have no question in my mind that it was politics.
He was very angry, and I can understand why. It was just so unfair.
Screw One Nation and get somebody. Get Scott Balson.
I did make a statement to the media when I left court that day, and it was actually a double-edged statement because I wanted to see how far they would go. And what I did in my statement was I said that I was amazed at the double standards going on, because here I was a citizen being put through the loop by the government, while within their ranks they had a man who was facing child sex charges and who was sitting in Parliament making laws for us. And they published that night.
We have a Queensland MP who's facing 50 child sex charges, making laws that affect me, you, and everybody in the state.
Now, they published that knowing that it breached the law. And it's interesting because I, by saying it had breached the law, they, by publishing it right across the whole of Queensland, breached the law, and yet, of course, no charges were ever laid.
If that's justice in Queensland, God help us, because the law isn't.
With his legal costs soaring, Scott decided to represent himself at the initial hearing on the 5th of January 2000. Inside courtroom 1 of the Ipswich Magistrates Court, things were getting underway. The magistrate, Donna McCullum, appeared just after 9 a.m. and dealt with a number of cases before proceeding with Scott's.
Through my past experiences with the magisterial process, I was actually very concerned about the person who would be hearing my case. But when I saw Donna McCullum, who was the magistrate who took my case in action, I warmed to her straight away, because I could see that she was someone who was very straight, she was very focused on things, and I believed I'd get a fair trial in front of her. As far as the events that took place that day, it was quite interesting, because when my case was called up, she went through the documents that the police had handed her, and she called for an adjournment for an hour, because she said she had never ever seen a summons like the one that I'd been given in her life before.
Neither Scott nor I were amazed at the interference that came from outside forces. Didn't surprise us one bit. We half expected it.
I took a great deal of comfort that she would, A, recognise there's something wrong with the summons, and perhaps the way the whole thing had been transacted, and also that she took the time to go out and see for herself what was going on. When she came back into the courtroom, it became very clear to me that she was concerned about what had been happening behind the scenes. And she made it very clear that she wanted to hear the case, almost as if she wanted to see that justice was done. I did make a statement to the media at the end of that hearing. Basically, I brought up the issue of Shreddergate, and I said, you know, the government should be getting fair dinkum and really sorting out the allegations that Lindeberg had raised regarding the shredding of documents which clearly demonstrated acts of pedophilia against wards of the state.
Like all great scandals, like Watergate, the initial issue, you know, the breaking in into Watergate was bad enough, but what's worse, it's a cover-up. And of course, in the cover-up, in the Heiner affair, it goes all the way through the system, right up to Government House, and it cuts right across. And so it is the cover-up. So it's no longer just a shredding. It involves abuse of power. It involves the cover-up of abuse of children, going to an unresolved pack rape of an Aboriginal girl, the payment of money, public officials not doing their job, being elevated to positions of high office now in Queensland, where the whole thing is it's like a pack of cards, where they all depend on each other. And it's just not going to last, because the truth will out.
Balson has alleged 2 other organisations, including a media outlet and a legal firm, have also breached the Sexual Offences Act.
The point has been raised now, and maybe Crown Law will look at the evidence and see what I'm saying. I hope so.
Police say if other publishing complaints have been received, they would be investigated. They won't confirm if any media or legal firms are under scrutiny, however. Leith Manifold, 10 News.
I realise that the media are not about what's right or fair. They're all about bias, politics and hidden agendas.
On the weekend following Scott's court hearing, Bill Darcy resigned. During the whole of 1999, the Labor Party had been able to use his critical vote to pass the legislation, while using the Sexual Offences Act to prevent the media from exposing the true nature of the man helping them to make laws in Queensland. His resignation at this time would ensure that he received a taxpayer-paid pension, because he had not been committed to trial or arrested at this stage.
Well, when you see double standards like this, it makes you both angry and frustrated, because I believe in the rule of law. And I believe in the values that my father and my grandfather stood for in this country, that everyone is supposed to be equal before the law. And when I see this happening in the state that I love, in the country that I love, it upsets me. And it makes me very determined that it ought not be allowed to pass. And there are other people who agree with this.
With his comments about being singled out becoming the focus of media reports following the preliminary hearings, Scott decided to add further weight to the allegations he made.
I wrote to the Office of Crown Law because I was getting no response from the DPP to my complaints. Again, it was a clear example of how they'd acted against me within a couple of days, and here we were many days later without even getting an acknowledgement that they'd had a complaint. Dear Sir, I wish to bring your attention to the fact that 2 organisations in Brisbane have published the name of a man facing child sex charges in Queensland. The proof of this offence was provided by the police in their brief of evidence against me. I have been waiting for them to act on the breach, but apparently they have not done so, resulting in this formal complaint.
It would seem fate was on Scott's side for a brief moment, when on January the 18th, Kerry Packer's National Bulletin magazine named Darcy just days before he was committed to trial. The magazine was on the shelves of Queensland newsagents the same week Scott had written and complained to the Attorney General. An ABC staffer had alerted him to the magazine's breach of the criminal law.
The President of the Queensland Council for Civil Liberties, Ian Dearden, says the magazine must be pursued for revealing the name. Dearden says, "There is already one person before the courts charged on a similar allegation. It would be hypocritical if any other media organisation that had similarly apparently breached the law was not also charged."
It made me very angry to consider the difference in time that it had taken to pursue me and the inaction against everybody else. But I wasn't surprised, because I'd realised quite early on that the whole judicial system in Queensland was prejudiced. There is not a separation of powers in Queensland. The politicians are clearly involved at all levels. The bureaucrats and the senior judicial departments are elected by the BT government. They're mates. All it takes is a phone call. It's that easy.
Scott was finding it difficult to have his complaints acted upon by the Commissioner of Police. Being referred to the Commissioner's legal advisor, Colin Strofield, he again expressed his concern that the 3-week delay was in contradiction to how he had been dealt with. He faxed Strofield after being avoided by the office on numerous occasions.
It should be of interest to you that I'm carefully recording and logging the remarkable disparity in the manner and speed with which allegations against me on the same charge were treated by the police force. I would remind you that the most basic foundation of the police force, impartiality when pursuing complaints, is becoming a casualty which reflects badly on your organisation.
After receiving no feedback on the complaints made, Scott again contacted the office on the 18th of February.
Asphalt said that they weren't going to pursue the Bulletin magazine because A, it would be too costly, and B, because they didn't have enough evidence against the paper, the magazine, despite the fact that it clearly came out before he was committed for trial, and clearly it had appeared in print. I knew from the very start that I was being singled out. There was absolutely no question about that. The way the media responded to my arrest, the speed of my arrest, the inaction against all these other parties, there's absolutely no question that this involved the government, involved senior bureaucrats, and involved the editorial staff at the Courier Mail. You know, it was a totally trumped up situation to try and intimidate me. Absolutely no question about it.
With legal bills totalling over $8,000 and the case yet to be heard, Scott decided to represent himself.
I felt terribly alone. The One Nation Party had basically walked away from me. They said it wasn't their problem. I was alone. I didn't have a wife. I didn't have anyone I could talk to. And it was just very, very stressful. I tried to prepare or finalize the information I was preparing for my trial. I couldn't focus on things. It was just, it was, I remember sitting in my office with just the computer screen light on, and I had these big glass windows that looked out over the Brisbane River. There are no houses on the other side, it's just forest. And I was looking out into the darkness, and I just felt that that's just like where my life was, right there. Nowhere to go. On the day of my trial, I got in there a few minutes late, and McCullum was just finishing off a couple of cases. Sat down at the front and noticed immediately all the familiar faces of the media, the vultures as I call them, just sitting there waiting to just put their own slant on the story. And I wasn't feeling well. I'd had a bad night. I was feeling very down. I was feeling very determined. And McCullum then called me up to address the bench, and I stood up, and I was just answering that my name was Scott Balson, etc., etc., and I blacked out. And I just fell backwards. I just remember everything went black, and I passed out, landed literally at the feet of the media in the front row. And I heard this mad scampering going on behind me as the media exited from the room. And the police prosecutor, very nice guy by the name of Ian Wright, he actually came to my aid, and everything was fuzzy. You know, it was just, I didn't know what was happening, and he sort of pulled me out of it and sat me up, and they adjourned the trial for a while, and he then said to me, he said, look, the magistrate wants to know if you want to adjourn the trial for another day when you're feeling better. And I said, no, I've been through 2 adjourned trials already, I wanted to proceed today. So they postponed it for an hour, and then the trial went ahead.
Shortly after 10 a.m, the case resumed, with the prosecution calling Channel 9's Melanie Wendt. For the charge to be upheld against Scott, the prosecutor had to produce a citizen who had seen the unlawful document which had resulted in the arrest. Following is a dramatised scenario involving Scott cross-examining Melanie Wendt.
I'd like to ask the witness firstly, did you view this page online, on the internet?
I did not. No, we had someone at work do that because I was in court that morning.
And could I ask you how you got that copy, that hard copy? Was it faxed to your offices or...?
No, there was a group of journalists that had various copies in court that morning, and everyone was distributed. Well, everyone just had a look and made copies. We all made copies.
Now, that's an act of publication. That's a breach of the Act. And every member of the media was breaching the Act by accepting copies of the article which named Darcy as a man facing child sex charges. And these were the turkeys who then went out after me, claiming my blood. The implication of what Melanie Wendt said was not lost on the magistrate. And that came out clearly when she actually gave her ruling. She could see, I think quite early on in this case, that I had been singled out. The next witness was a senior prosecutor from the DPP, David Bullock. I wanted to clarify who had laid the original complaint against me. Is it true that you told my lawyer, Paul McCann, on the 28th of July last year that the Courier Mail had originated the complaint?
That's what Mr. Miller had told me, but I stress that's hearsay and I don't know what the source of Mr. Miller's information is.
So that is a fact?
Well, that's what I told him, what Mr. Miller had told me.
Okay, and that came from the person in charge of the DPP?
Yes.
That the Courier Mail had lodged a complaint?
Yes, they made a complaint.
Thank you, Your Honour. I just wanted to clarify that. The implication of that was enormous because it clearly demonstrated that my arrest was made without any evidence being held at all. One of the first things that the police raised in the trial was an extraordinary statement that I had a prior criminal offence or a prior criminal record. Now, being someone who's never been in the courts before, I found this quite extraordinary. And I asked the arresting officer, Leanne Myers, if she would mind telling me what that criminal charge was. In your statement in point 10, you say I was arrested in relation to another charge. Could you tell me and the court what that other charge was?
That was pertaining to another matter not before the court, Your Worship. I seek permission for a direction.
There might be some disadvantage in bringing that out before the court, Mr. Balson. Generally, charges that are not before the court, as a general rule, should not be brought before the tribunal of fact. I don't know whether you've taken any legal advice on the way in which to conduct this hearing.
Your Honour, I'll leave it there. It was only when I took the state of Queensland to the Supreme Court that under freedom or under discovery, I was given access to a document, which is the one that the arresting officer had referred to, where the police had trumped up in a document a charge against me. And if it wasn't so serious, it would be quite laughable. But on that document, the police claimed that I had a charge, a criminal record of possession of dangerous drugs. And I don't. And it's there in black and white. I actually wrote to the Office of Crown Law, obviously once this document came to me under discovery, and I sought clarification on this issue. And they confirmed to me in writing that I have absolutely no criminal charges against my name, and they were unable to explain how that appeared in that document. Now, what's interesting is that that document was drawn up on the same day as I was arrested, when there was an awful lot of skullduggery going on. So why not just put another nail in the coffin? I was appalled by the fact that the police had not only taken a copy of my computer hard disk with all the confidential One Nation files, but that they'd put them onto a central police computer where anybody in the police force in that division, we're talking about 20 people over the time, could access and take copies of those files away with them.
Following is a dramatised scenario involving Scott cross-examining Darren Freestone.
Mr. Freestone, as I was a One Nation webmaster at the time, were you aware that the files you copied included sensitive political information related to the One Nation Party?
You mentioned that fact to me the day I was there, 30 July. You mentioned that to me and to the other investigators.
So you were aware of that fact?
You mentioned that, yeah.
Has anyone else copied these files or been given access to the files copied by you?
As part of our procedure, when we copy that information onto the hard disks, we make a complete and full copy and we store that for backup purposes so that when we need to look at it again and again, I've got that copy to refer to. But during the examination, I was the only person that had access to the files in my unit.
You say during the examination. Where are those files now?
They're archived and kept in our storage area.
Can anyone get access to them?
Anybody in our unit can access them. They can.
So since July last year, anyone in your unit in the police force has access to sensitive One Nation documents?
It's not in a... Okay.
Technically, yes or no?
Technically, yes.
Now we're talking about political information of a very confidential nature, which included email lists, private letters, policy, a whole range of issues which could have been fed back to, and might well have been fed back to, the Labor Party. And that is just an appalling way for the government to operate.
It was now Scott's turn to either give evidence or call for a no case. He asked for a mistrial and asked for the case to be dismissed. The prosecutor, Ian Wright, submitted his case calling for Scott to be guilty. The magistrate adjourned the trial for lunch and asked that the case be restarted at 2 p.m.
Ian Wright came up to me at lunchtime and said that in his case he had a real problem in actually making it stick because there was no direct link between me and the article that was published. And he said there was more than likely that the charges would be dropped and I'd be found not guilty.
It seemed the police had been covering their tracks as upon return, Wright confessed to Scott that they had found a link.
What the police prosecutor came up with after lunch was that my name, i.e. Scott, appeared on quite a few of the letters to the editor, and basically he was saying that because my name appeared in these letters that I was the editor of the newspaper, because the newspaper was by affiliation or association with the One Nation and the Web. It was under my jurisdiction and I should be held responsible.
Your Worship, just one point. I don't believe that there is any evidence before the court that the publication was made outside of Queensland. The only evidence that we have is the telephone conversation and the fact that the article was located on the defendant's hard drive.
My response to that was that there wasn't enough evidence, and also that when you download a web page from the internet, it automatically puts a copy of that in your computer anyway. I certainly wasn't going to let on that I was the publisher of the article because I knew that this is a system and I had to play by their rules. My summation of the trial was, I think, quite extraordinary as far as trials go, because I made it very clear to the magistrate that I wasn't there to talk about whether I was guilty or not of naming Darcy. I was there to reveal to everybody gathered in the courtroom and put on the record how compromised the media were and how politically motivated my arrest had been. This is the same pack of dogs that came after me at that time and demanded that the Attorney General do something about the allegation that I had named this man on the internet. I'm still the only person in history who has been brought before the courts on this charge. I have been singled out by the government on this charge. There is insufficient evidence before the court that can be relied upon linking my company to the internet newspaper. There are serious flaws that cannot be overcome by the prosecution. I therefore ask that charges be dismissed. During my submission to demonstrate to the magistrate how I'd been singled out, I tabled 2 articles that I'd got from the State Library, which clearly named Darcy, which had the Courier Mail header on them, and which had been printed during the time when no publication should have taken place. Unfortunately, I couldn't present them to her officially because I wasn't in the witness box, but I was able to basically say, here are the articles, here's the signature, and this is what the article's about. Now, because Darcy had already been committed for trial at this stage, I could obviously mention his name at the court as well. Your Honour, I believe that your decision today will have a major impact on freedom of speech in Australia in the new millennium. I hope and pray that you can see the role that the Mudoch press have played in trying to quash that. My trial today is not about the naming of Darcy. It is all about publishing on the internet, the last domain of freedom of speech in this country. What I'd found on the internet and what I raised in my summation was a legal argument by an academic that an act of publication here in Queensland and a document that appears overseas could not be brought into a legal action here in Australia because it had actually appeared in another country. I would quote from an article by the Australian National University's Robert Clark. He speaks at international law forums on the internet and the law. And he says, "The law has failed dismally in its attempts to cope with the first 50 years of information technology. The bench knows little. Barristers are for the most part ineffectual in their attempts to describe technology in ways that are accurate yet understandable by judges. No mechanism has yet been whereby judges can themselves use the services of experts to assist them in understanding the matters that come before them. In short, even within jurisdictions, cases involving information technology are largely a lottery."
It was after 3 p.m. when Scott concluded his submission to Magistrate McCullum, and she reserved her decision until Monday the 20th of March. That night, none of the television stations covered what had happened in court, and the Courier Mail had no reference to the comments made by Scott, despite a reporter being there to record it. It was only ABC Radio who carried 2 reports and the Queensland Times with a page 3 article. On Monday the 20th of March, Magistrate McCullum spoke at length about the evidence tendered, the unusual nature of the court case, and the lack of direct evidence implicating Scott as the author of the article.
And it was probably one of the most extraordinary decisions I think I would hear, even if I was involved in the law, because she hammered the system.
I have to say, I do not think enough information was provided about the workings of computers and or the internet. For those from a generation not as familiar with the intricacies of computers, as seems to be the case for younger people, its mysteries are probably as manifold as was the case for the generation coming to terms with radio or television. It is therefore necessary, in my view, for the prosecution to explain all of the steps along the way. At the end of the day, I am of the view that the evidence is just not sufficient for me to be satisfied that the prosecution has discharged its onus of proof.
She made it very clear that she was very unhappy that this case had actually gone before her. She stated quite clearly that David Bullock had never met me, didn't know who I was, and that wasn't evidence. She made it clear the police never had any evidence against me, and she dismissed the charge completely.
Magistrate McCullum found Scott not guilty.
The real battle that I've been facing is actually with the system itself, which is a real tragedy in what's supposed to be a democratic system. The major players, the government, the politicians, the senior bureaucrats, and the mainstream media, they've all clearly acted in cahoots to go out and get me, for no other reason than perhaps I was exposing some of the things that they were up to and things that they were covering up. Now, that isn't a democracy. The other real problem I have in Queensland is the way the separation of powers has been compromised, and it's clearly been compromised. There are people in Queensland jails right now who shouldn't be there, and they're there because they cannot afford legal representation. And some of them are probably there for political reasons as well. We don't know about it. It's only because I'm such a good researcher that I was able to put the whole story together. One wonders how many other thousands of cases are out there where the system has actually gone after someone for their own reasons. And that is tragic, it's sad, and it's sick.